We've been talking a lot amongst ourselves as lawyers in our law firm about drug recognition evaluator examinations. What typically is happening is the officer who makes the traffic stop takes the person through the standardized field sobriety tests for alcohol and then administers a preliminary breath test, or PBT. That's the handheld PBT that you are offered before the arrest. Person blows zeros. Person doesn't show what's called HGN, or horizontal gaze nystagmus. So the officer is under the impression that the person might be impaired but is not impaired by alcohol. And so we've got a case pending now where the officer literally puts the person under arrest, takes her to the police department for an evaluation by a so-called drug recognition examiner or evaluator, without reading her Miranda warnings. The Court of Appeals in Indiana, in a case that was just issued on December 29th, courtesy of my colleague L. Scott Pejic in Indiana, that came to me through the National College for DUI Defense, talks about this very fact pattern and finds that this is a violation of the Constitution, at least in that state, citing to federal precedent Terry versus Ohio about what information the officer needs, what evidence the officer needs in order to do a full-blown detention, and then what type of examination this DRE examination is. It's a 30-minute exam that's a little bit like a medical exam, so to speak, and the court here said that's too intrusive, that's too invasive, that takes too long, and a person is clearly in custody and detained. They have to be given their rights before this examination can be conducted.